Hey guys, tonight we're stepping back, way back, into a world where justice wore a very different face, and the accused, well, let's just say they weren't always bipedal. Imagine, if you will, the flickering torchlight in a cold, stone courtroom, the hushed whispers of the gathered crowd, the stern faces of the robed judges, and the heavy, expectant silence as the accused is brought forth. You trudge through the mud-soaked streets of a forgotten medieval town, the air thick with the scent of wood smoke and damp earth, oblivious to the bizarre spectacle you're about to witness. Your modern sensibilities are about to be thoroughly rattled, and frankly, you probably won't survive this journey with your understanding of law intact. So, before you get comfortable, take a moment to like the video and subscribe, but only if you genuinely enjoy what I do here. And hey, let me know in the comments where you're tuning in from, and what time it is for you right now. Now, dim the lights, maybe turn on a fan for that soft background hum, and let's ease into tonight's journey together. You find yourself in a rather drafty, dimly lit chamber, the kind of place where the very stones seem to hum with centuries of hushed judgments and solemn pronouncements. The air hangs heavy with the scent of damp wool, old parchment, and something vaguely earthy, perhaps from the unwashed masses packed into the back. You stand amongst them, a silent observer, your eyes adjusting to the gloom. High above, narrow windows, barely more than slits, offer only a grudging sliver of gray light, making the flickering candles on the magistrate's desk work overtime, casting dancing shadows that warp the already serious faces of the men arrayed before you. This isn't the clean, sterile courtroom you might be used to seeing on TV. This is raw, unrefined medieval justice, a place where the weight of tradition presses down on every soul present. You crane your neck, trying to get a better view. The room is mostly wood and stone, unadorned save for a crucifix hanging prominently behind the dais. The judge, a man whose stern countenance seems carved from the same hard oak as his bench, sits with an air of immense authority, his robes a deep, somber hue. Beside him, a clerk, cool poised over a hefty ledger, looks ready to scratch down every syllable. Before them, a small, enclosed dock, usually reserved for human transgressors, stands empty for now, waiting. You feel a prickle of anticipation, a nervous flutter in your stomach. What grand, dramatic human crime has brought this assembly together? A dispute over land? A charge of theft? Perhaps something more scandalous, like a tale of forbidden love or a witch trial. Your imagination, steeped in historical dramas, runs wild. Then, a sudden shuffling breaks the silence near a side entrance. A murmur ripples through the crowd, a collective intake of breath. You lean forward, straining to see past the shoulders of the burly peasant in front of you. Two men, burly and grim-faced, are leading something into the courtroom. You squint, trying to make sense of the shape. It's low to the ground. It's moving with a curious, shuffling gait. There's a snuffling sound, and a faint, rather pungent barnyard aroma begins to waft your way, cutting through the damp stone and old parchment. Your eyes widen. Your jaw, if you weren't so committed to being a silent observer, would surely drop to the floor. Because what they are leading, with a thick rope looped around its neck, is not a man. It's not a woman. It's certainly not a witch, unless witches have developed a penchant for rooting around in the mud. No, what stands accused, right there in the dock, looking utterly bewildered and perhaps a little miffed, is a pig. A rather large, pinkish pig, to be precise, whose small, intelligent eyes blink owlishly at the assembled human faces. You half expect it to squeal, "I demand a lawyer," but it merely snuffles quietly, perhaps pondering the existential dread of being tried by a species that regularly turns its kin into bacon. This isn't a joke, you realize with a jolt. This isn't some village prank or a whimsical local custom. The judge's face remains utterly solemn. The clerk's quill is still poised, ready to record the proceedings against this porcine defendant. The crowd, far from giggling, looks on with grave interest, some nodding sagely as if this is the most normal thing in the world. And in this forgotten corner of medieval Europe, it absolutely was. You've stumbled into the hidden world of medieval animal trials, a legal spectacle so bizarre, so utterly alien to your modern understanding of justice, that it feels like a dream. The sheer absurdity of the scene is almost overwhelming. You watch as the pig, perhaps sensing the gravity of the situation, lets out a small, nervous squeal, which is quickly shushed by one of its escorts. You can't help but wonder what the pig is thinking. Is it contemplating its legal options? Is it perhaps considering a plea bargain? Or is it simply wondering when it's going to be fed? You imagine its inner monologue. Honestly, the indignity. All this fuss just because I might have accidentally trampled a few turnips. And where's my representation? Do they even have a good portfolio lawyer in this town? It's a surreal moment, a collision of the mundane and the utterly preposterous. And yet, this was a widespread phenomenon. Historians still argue whether these trials were primarily symbolic, a way for communities to reassert control and moral order, or if they genuinely believed animals possessed a degree of moral culpability. But what is undeniable is that these were formal, legally recognized proceedings. You weren't just witnessing a one-off oddity. Animal trials were a surprisingly common feature of the medieval legal landscape across Europe, from the 13th to the 18th centuries. While pigs were certainly the most frequent offenders, their close proximity to human settlements and their rather inquisitive, sometimes destructive, nature often led to conflicts. They were far from the only creatures to find themselves on the wrong side of the law. You can almost hear the judge clearing his throat, ready to begin the interrogation of the silent, snuffling accused. The sheer weight of medieval thought, the intricate web of theology, law, and superstition that underpins such a practice, begins to press in on you. It's a world where the lines between human and animal, between sacred and profane, were drawn in ways that seem utterly alien now. You might think, from your vantage point in the future, that this was simply a sign of a less enlightened age, a quaint curiosity. But the seriousness with which these trials were conducted suggests something far deeper. This wasn't a game. Lives, or at least the continued existence of these animals, hung in the balance. And the entire community watched, judging. You shiver slightly, partly from the cold seeping through the stone walls, and partly from the dawning realization of just how profoundly different the medieval mind truly was. Imagine the discussions around the hearth fire the night before such a trial. Did you hear? Old Farmer Giles's sow is up before the magistrate tomorrow. Accused of, well, poor thing. And the neighbors would nod sagely, perhaps offering advice on a good legal strategy for a nonverbal defendant. It's a quirky tidbit that a common method for handling the accused animal was to ensure it was dressed or presented in a way that mimicked human defendants, sometimes even led in on a leash like a prisoner, as this pig is now. It was all about maintaining the solemnity and gravity of the court, even when the accused was more interested in a good wallow than a legal defense. The medieval legal system, in its own unique way, bent over backward to ensure that even the most unlikely defendants received their day in court. You can almost hear the rustle of the judge's robes as he prepares to address the court, and the pig in equal measure. You settle deeper into your imaginary, plush armchair, a soft, ambient hum filling the air around you. As we drift further into the peculiar legal landscape of medieval Europe, the question that likely whispers through your mind, perhaps as gently as a summer breeze rustling through ancient tapestries, is not what happened in these animal trials, but why. Why, in the name of all that was rational or what we now consider rational, did a society dedicate so much solemn judicial effort to prosecuting a goat, or a rat, or even a humble, unsuspecting pig? To truly grasp this, you must first shed your modern sensibilities, as easily as you might slip off a pair of too tight shoes, and step into the medieval mind. It's a world where the veil between the natural and the supernatural was incredibly thin, almost transparent. Every rustle in the forest, every sudden illness, every bountiful harvest or devastating blight was imbued with meaning. It wasn't just random chance. It was often seen as divine will or, more ominously, the dark machinations of unseen forces. In this worldview, animals weren't simply unthinking automatons. Oh no, they were creatures of God, yes, but also capable of agency, of moral failing, and even, terrifyingly, of being instruments of the devil. Imagine, if you will, the flickering candlelight in a smoky peasant hut. You're listening to the hushed whispers of your neighbors, recounting a tale of a sow that, in a moment of unimaginable horror, attacked and killed a child. In our time, you'd think of it as a tragic accident, perhaps an aggressive animal or a desperate one. You might mourn, you might even consider the animal dangerous and have it put down. But in the medieval era, the very act of an animal committing such a heinous crime suggested something deeper, something profoundly unsettling. Was it merely a beast acting on instinct? Or was it something more sinister? Had the sow been possessed? Was it a sign of divine displeasure? Was there a demonic influence at play? These weren't idle questions. They were pressing concerns that gnawed at the fabric of the community's spiritual and social order. This brings us, quite naturally, to the bedrock of medieval legal thought, the Bible. Not just as a spiritual guide, but as a literal, tangible legal code, interpreted and applied with a rigor that might surprise you. Among the many commandments and narratives, certain passages stood out, illuminating the path to animal accountability. The most frequently cited, the veritable legal cornerstone of these beastly trials, comes from the book of Exodus, chapter 21, verse 28. It states quite unequivocally, "If an ox gores a man or a woman to death, the ox shall be stoned, and its flesh shall not be eaten, but the owner shall be clear." Now, just let that sink in for a moment. This wasn't about the owner being held responsible for negligence. The ox itself was to be executed. Its flesh was declared unclean, unfit for consumption, as if the very act of its crime had defiled it. This wasn't merely practical pest control. It was a profound act of ritual purification and justice. You might be thinking, but what about the owner? Surely they had some responsibility? And indeed, later verses in Exodus 21 go on to detail scenarios where the owner could be held responsible if they knew the ox was dangerous and didn't control it. But the initial, striking command was about the ox itself. This mainstream historical fact, the direct biblical precedent, provided a powerful justification for the trials that would unfold centuries later. It wasn't just a quirky local custom. It was rooted in divine law, interpreted and enforced by both secular and ecclesiastical courts. Beyond Exodus, other biblical passages reinforced the idea of animals having a place within a moral framework. Genesis 9 verse 5, for instance, proclaims, "And for your lifeblood I will require a reckoning. From every beast I will require it, and from man." While open to interpretation, this verse could be seen as God himself holding animals accountable for taking human life. It suggested a cosmic order where even a beast, by shedding human blood, disrupted the divine plan and required a reckoning. It painted a picture of a universe where every creature, from the lowliest worm to the mightiest king, was ultimately answerable to a higher power. So, you see, the medieval mindset wasn't necessarily that animals understood the law in the way a human would, or that they could feel guilt. That's a common modern misconception. Instead, it was often about the consequences of their actions, particularly when those actions threatened the human community or violated divine decree. An animal that committed a grave offense, especially one resulting in death, wasn't just a nuisance. It was a source of ritual pollution, a tangible manifestation of disorder. The trial, therefore, became a way to cleanse the community, to restore balance, and to appease a potentially wrathful God. It was less about teaching the pig a lesson, and more about reassuring the villagers that justice, divine and earthly, was being served. Imagine the relief, the collective sigh, as the community felt the weight of that transgression lifted. This brings us to a slightly more nuanced, perhaps even quirky, tidbit about their thinking: the concept of malice in animals. While they didn't attribute human-level consciousness, some legal thinkers wrestled with the idea that certain animals, particularly pigs, were seen as having a degree of cunning or even malevolence. Pigs, being omnivores and often living in close proximity to humans, were frequently involved in incidents with children. Their intelligence, combined with their sometimes aggressive nature, might have led to the belief that an act of violence wasn't purely accidental, but perhaps carried a dark, intentional undertone. It's like when your cat knows it's not supposed to knock that vase off the shelf, but does it anyway, just to make eye contact as it shatters. The medieval mind might have seen that as a form of feline malice, deserving of a stern talking to, or perhaps a formal summons. Moreover, these trials weren't always about punishing the animal directly for its sin. Sometimes, particularly with widespread pests like rats or locusts, the proceedings were more akin to an ecclesiastical exorcism or a public shaming. The church would issue stern warnings, even excommunications, not because they believed a rat had a soul to save, but because they believed the animals were instruments of divine punishment or demonic forces. By formally accusing them, by casting them out, they were attempting to break the spiritual hold over the plague, to restore God's favor to the afflicted land. It was a legal and spiritual battle against an unseen enemy, using the only tools they knew how. Now, you might wonder, did everyone truly believe an ox could stand trial like a human? This is where a fascinating scholarly debate emerges. Historians still argue whether these trials were truly about animal culpability in the way we understand it today, or if they were more about human anxieties, ritual purification, and the symbolic assertion of human dominion over the natural world. Was the pig punished because it was guilty, or because its death was necessary to cleanse the community of a defiling act? Was it a way for communities to process trauma and reassert control in a world that often felt chaotic and unpredictable? The answer, like so many things from the past, is likely a complex blend of all these factors, woven together like the intricate patterns of a medieval tapestry. Think of it this way. In a world without modern science, without understanding of germ theory or animal behavior, how do you explain a sudden plague of locusts destroying your crops, or a beloved child succumbing to an animal attack? You look for meaning, for justice, for a way to reestablish order. The legal system, both secular and religious, was the primary mechanism for doing so. It provided a framework, a ritual, a public spectacle that reassured the populace that even the most unnatural acts by the natural world would not go unaddressed. It was a way of saying, we see this transgression, and we will bring it into the light of justice, no matter how furry or feathered the culprit may be. It's a bit like when you give a stern talking to your smart speaker for playing the wrong song, even though you know it doesn't understand you. It's about asserting your authority, your control over a world that sometimes feels just a little too wild. So, as you ponder the medieval mindset, remember it was a world steeped in faith, in a literal interpretation of Scripture, and in a profound need for order and meaning in the face of inexplicable events. Animals were not just creatures. They were players, sometimes tragic, sometimes villainous, in the ongoing drama between humanity, the divine, and the forces of chaos. And when they stepped out of line, when they committed an act that defied the natural order, medieval society was ready to bring them to justice, with all the solemnity and ceremony due to any human offender. You trudge deeper into the curious corridors of medieval justice, your footsteps echoing softly on the ancient flagstones. We've peered into the general concept, but now prepare yourself, because you're about to meet the undisputed heavyweight champions of the medieval animal courtroom. The pigs. Yes, you heard that right. While other creatures occasionally graced the dock, it was the humble pig who found itself, with surprising regularity, staring down the stern gaze of a medieval judge. Imagine, if you will, the bustling, muddy streets of a medieval French village. The air is thick with the scent of wood smoke, damp earth, and, well, pigs. These weren't the neatly penned, factory-farmed animals we know today. Medieval pigs, particularly in rural areas, often roamed semi-wild, acting as the village's unofficial, four-legged sanitation crew, gobbling up scraps and refuse. They were everywhere, rooting through muck, snuffling at doors, and generally being an omnipresent, if somewhat grimy, part of daily life. This close proximity, however, came with its own unique set of problems. It's precisely this intimate, often unsupervised coexistence that led to the astonishing frequency of pig trials. You see, when a creature is allowed to wander freely, especially one with significant tusks and a powerful build, accidents happen. And in the medieval world, an accident involving a pig often meant an assault. The primary victims? More often than not, vulnerable infants or young children left unattended, perhaps crawling near a dwelling or playing unsupervised in the village square. A pig, driven by hunger or perhaps simply startled, might lash out, causing injury or, tragically, death. When such a calamity occurred, it wasn't simply brushed aside as a force of nature. Oh no, The medieval mind, as we've discussed, saw intent or at least culpability where we might see instinct. So, when a pig committed an act of violence, it was seen as a crime, and the pig itself was deemed the perpetrator. This wasn't just a local custom. Mainstream historical fact alert. Documented pig trials occurred across France, Germany, Switzerland, and even parts of England, with hundreds of cases recorded between the 13th and 18th centuries, making them by far the most common type of animal prosecution. Picture the scene. News spreads like wildfire through the village. A child has been attacked. The community is gripped by horror and outrage. The culprit, a sow perhaps or a boar, is identified. And then the wheels of justice, astonishingly, begin to turn. The pig isn't simply slaughtered on the spot, as one might expect. No, that would be too simple, too unjudicial. Instead, this porcine perpetrator is formally arrested. You can almost hear the squeals of protest as the bailiff, perhaps with a touch of trepidation, apprehends the accused. Sometimes the pig would even be held in a local jail, sharing a cell, presumably with less odorous human miscreants. Imagine the complaints from the human inmates. "Honestly, Your Honor, the smell. And he keeps trying to eat my shoes." Once secured, the pig would be brought before a court, often an ecclesiastical court, but sometimes a secular one, depending on the jurisdiction and the specific nature of the crime. This wasn't some kangaroo court held in a barn. This was a proper legal proceeding mirroring, in almost every detail, the trials of human defendants. The court would convene, usually in a formal setting, a town hall, a monastery, or a baron's court. A judge would preside, often clad in robes, perhaps adjusting his spectacles, looking down at the grunting, snuffling defendant in the dock. The charges would be read aloud, often in Latin, detailing the heinous act committed by the accused pig. You can almost hear the solemn tones, the Latin words rolling off the clerk's tongue, describing the malicious and felonious assault of a creature that probably just wanted a snack. And then, the truly astonishing part, the pig would often be assigned legal counsel. Yes, a lawyer. A human, learned, often well-respected lawyer, whose job it was to represent the best interests of a pig. You might wonder, what exactly does a lawyer argue on behalf of a pig? Perhaps they try to plead temporary insanity, or argue the pig was merely defending itself, or perhaps, the most common defense, that the pig was simply following its natural instincts and therefore lacked malicious intent. I picture the lawyer, sweating slightly, trying to get his client to offer a coherent plea. "Your Honor, my client, Bartholomew, wishes to plead." Oink! It must have been a challenging, if not utterly bizarre, career choice. Witnesses, usually the parents of the victim or other villagers who saw the attack, would be called to testify. They'd recount the terrifying details of the incident, describing the pig's actions, perhaps pointing an accusatory finger at the snorting beast. The court would listen intently, weighing the evidence. You can almost smell the fear and the lingering trauma in the air as they described the pig's aggression. The proceedings were meticulously recorded, with scribes painstakingly documenting every testimony, every pronouncement, every grunting interjection from the defendant. Quirky tidbit alert. In one particularly famous case from 1457 in Savigny, France, a sow was put on trial for attacking and killing a 5-year-old child. Not only was the sow tried, but her 6 piglets were also rounded up and brought into court as co-defendants. The piglets, however, were acquitted, likely because the court deemed them too young to have fully participated in the act or to understand its gravity. The sow, unfortunately, was not so lucky. Imagine the scene. A stern judge, a courtroom full of solemn faces, and a litter of bewildered piglets looking utterly adorable, yet somehow implicated in a capital crime. It's enough to make you chuckle, despite the grim implications. The verdict, almost inevitably, was guilty. After all, the evidence was usually overwhelming. A dead or injured child, and a pig that had clearly been involved. Historians still argue whether these trials were primarily about justice for the victim, a ritualistic purging of evil from the community, or a means to assert human dominance over the natural world. Regardless of the underlying motivation, the judgment was pronounced with all the gravity reserved for human capital crimes. And then came the sentence. For pigs, this was almost always death. But not just any death. Oh no, this was a public execution, often mirroring the punishments meted out to human criminals. The pig might be hanged, sometimes even dressed in human clothes for added symbolic humiliation. Or it might be broken on the wheel or even burned at the stake, depending on the severity of the crime and the local customs. The execution served as a stark warning, not just to other pigs who presumably wouldn't understand, but to the human community, reinforcing the idea that even animals were subject to divine and human law. It was a spectacle meant to cleanse the community and reaffirm order. In some cases, the pig's carcass would be treated with further indignity, perhaps being paraded through the streets or left on display as a deterrent. The pig's owners, too, might face fines or other penalties, not for their own actions, but for failing to control their property, blurring the lines between the animal's culpability and the owner's responsibility. It's like your dog digging up the neighbor's prize-winning roses, but instead of a stern talking to, Fido gets a court summons and you get a bill for a public hanging. Talk about escalating quickly. The pervasive nature of pig trials speaks volumes about the medieval worldview. These animals were not just livestock. They were considered moral agents, capable of committing acts that warranted formal judicial process and severe punishment. The meticulous records, the presence of lawyers, the formal pronouncements, it all underscores a deep-seated belief system where the boundaries between human and animal responsibility were far more fluid than we can comprehend today. It's a testament to a time when every aspect of existence, even the unruly behavior of a barnyard animal, was filtered through a lens of law, morality, and divine order. You've just peered into the curious case of the medieval pig, a creature surprisingly often found in the dock, facing charges that would make a modern barrister scratch their head. But hold that thought, because as you drift deeper into this twilight world of peculiar justice, you discover that the pig was far from the only animal to feel the cold, hard gaze of the medieval law. No, your journey into the animal courtroom extends far beyond the sty, encompassing a veritable menagerie of the accused. Imagine, if you will, the bleating of a goat echoing not across a sun-dappled hillside, but within the hallowed, often chilly, confines of a medieval court. Goats, with their notoriously stubborn dispositions and penchant for mischief, were frequent offenders. You might picture them, eyes wide and uncomprehending, perhaps still chewing contentedly on some ill-gotten scrap, while a solemn judge in a heavy robe pores over a parchment detailing their misdeeds. Their crimes? Often they were charged with property damage, the destruction of crops, the chewing through of fences, the trampling of gardens. A goat, you see, was not merely an animal in the medieval mind. It was a property owner's bane, a four-legged agent of chaos capable of causing real economic hardship. You can almost smell the faint scent of damp straw and nervous animal as the proceedings begin. But the accusations against goats could be far more serious than mere horticultural havoc. There are documented cases, chilling in their absurdity to our modern sensibilities, where goats stood trial for assault, even for homicide. Picture a scene in a dusty village square. A goat, perhaps startled or simply in a bad mood, uses its formidable horns to gore a child or an unsuspecting adult. In the medieval legal framework, this was not simply an unfortunate accident caused by an animal. It was an act that demanded accountability. The community, grappling with the tragedy, needed an explanation, a culprit, and so the goat would be formally charged. A legal representative, often a local cleric or a designated advocate, appointed to represent its silent defense. You might wonder, with a sleepy chuckle, if the goat's lawyer ever advised it to plead the fifth. Given their usual demeanor, they'd probably just stare blankly and then try to eat the evidence. Then your gaze shifts to the mighty oxen, beasts of burden whose sheer power made them indispensable to medieval agriculture. You can hear the lowing, a deep, resonant sound that once filled the fields and farmyards of Europe. Oxen pulled plows, hauled carts laden with goods, and were the very backbone of the agrarian economy. Yet, this immense strength, so vital for prosperity, also carried with it the potential for grave danger. An ox, spooked or simply clumsy, could easily trample a person, kick out with devastating force, or gore with its powerful horns. And when such a tragedy occurred, particularly if it resulted in death, the legal machinery of the medieval world would grind into action. Imagine the scene. A farmer, perhaps, has been fatally gored by his own ox. The village is in mourning, but also in shock. The ox, a creature that had been a livelihood, now stands accused of a capital crime. Mainstream historical fact tells us that oxen were absolutely crucial to medieval society, their strength powering the very engine of survival. Their trials highlight a profound tension: the invaluable utility of the animal versus its perceived culpability when it caused harm. The court would meticulously gather testimonies from witnesses, neighbors who saw the incident, perhaps even the family of the deceased. Was the ox provoked? Was it a known danger? Or was this an act of pure, unadulterated beastly malice? The questions were asked, weighed, and deliberated with a gravity that seems almost comical to us now, but was deadly serious then. The air in the courtroom would be thick with the smell of damp earth and human anxiety, punctuated only by the occasional restless shift of the accused animal. And finally, you turn your attention to the most complex and intimate of medieval animal relationships: that with dogs. Unlike pigs, goats, or oxen, dogs were not just livestock or beasts of burden. They were companions, protectors, hunters, and sometimes, sadly, instruments of human will. This complexity made their trials particularly intriguing. A dog might be accused of attacking livestock, a common and economically damaging offense. You can almost hear the furious barks of a guard dog, now brought before the judge, accused of savaging a neighbor's sheep. Such cases were relatively straightforward, often resulting in the dog's execution, a grim warning to other canine delinquents and their owners about the sanctity of property. But then you encounter the truly bizarre. Some dogs were put on trial not just for their own actions, but for their perceived complicity in human crimes. This is where the quirky or fringe tidbit comes into play. There are accounts of dogs being implicated in cases of theft, not merely as the object of theft, but as an accomplice. Imagine a thief caught red-handed, with his loyal hound standing guard over the stolen goods. In some medieval courts, that dog could be considered an accessory, tried alongside its human master. You can almost hear the dog panting nervously, perhaps wagging its tail at the wrong moment, entirely oblivious to the legal storm brewing around its furry head. Did the dog know it was aiding a crime? Did it understand the concept of stolen property? These are questions that, of course, were never truly answered, but the very act of prosecuting the dog reveals a profound, if misguided, belief in animal agency. This leads us to a fascinating scholarly debate. Historians still argue whether these trials were truly about punishing the animal, or if they served as a public ritual to cleanse the community, to assign blame in a world that sought order in every chaotic event. Was the dog merely a proxy for its owner's negligence or guilt, or did medieval people genuinely believe the dog possessed a criminal intent? The truth, as is often the case with history, is probably a complex blend of both. You can almost feel the weight of this intellectual puzzle pressing down, even as your eyelids grow heavy. The process for these non-pig animals mirrored that of their porcine counterparts. Lawyers were appointed, evidence was presented, often eyewitness accounts of the animal's destructive behavior, and formal judgments were rendered. You might see a solemn procession leading an accused ox, its lowing a mournful counterpoint to the hushed murmurs of the crowd, to the place of judgment. The air would be thick with anticipation, a strange blend of legal formality and deep-seated superstition. The medieval mind, you see, was nothing if not thorough in its application of justice, even when that justice was meted out to a creature that likely only understood the difference between a full belly and an empty one. It makes you wonder if they ever tried to cross-examine a particularly uncooperative goat. Did you, or did you not, consume Farmer Giles's prize-winning cabbages? And the goat would just stare, perhaps chew its cud, and probably contemplate whether the bailiff's tunic looked tasty. The sheer variety of animals brought to trial, from the bleeding goat to the powerful ox, and even the loyal dog, underscores the widespread nature of this peculiar legal phenomenon. It wasn't just an isolated incident or a regional oddity. It was a deeply ingrained aspect of medieval European legal thought. These animals, regardless of their species, were seen as having violated a fundamental societal compact, whether through direct harm or through the destruction of vital resources. And for that, they had to face the music, or rather, the solemn pronouncements of the court. The gavel would fall, the sentence would be read, and another chapter in the hidden world of medieval animal trials would close, leaving you to ponder the strange logic of a bygone era. So, you've settled into the peculiar rhythm of medieval justice, where pigs can stand trial and goats get their day in court. You've probably started to feel a comfortable, if slightly bewildered, understanding of how a medieval mind might extend legal accountability to a biting dog or a goring ox. But now, you need to take a deep breath, because we're about to plunge into a realm of legal absurdity that stretches the very fabric of your modern understanding. Prepare yourself, because we're moving from the barnyard to the garden, from the four-legged to the six-legged, and beyond. You're about to witness the truly bizarre spectacle of medieval insect trials. Imagine, if you will, a village bathed in the soft, golden light of a summer afternoon, a gentle breeze rustling through the fields. Sounds idyllic, right? But then you notice it. A faint, persistent hum. A shimmering haze on the horizon. And then the horror. Not a rampaging boar, but a silent, creeping army. Caterpillars, inching relentlessly across your precious crops. Locusts, descending like a biblical plague, stripping fields bare in hours. Weevils, gnawing away at your stored grain, threatening your very survival through the winter. Slugs, leaving slimy trails of destruction through your vegetable patch. These aren't just nuisances. In a society teetering on the edge of subsistence, they are existential threats. And when your crops are your life, and prayer isn't quite cutting it, what do? You drag those tiny, chitinous villains to court, of course. Yes, you heard that right. Insect scourges, pestilential plagues, creeping crawlies. They all found themselves, or rather, their collective species, facing formal legal proceedings. It's hard to wrap your 21st century brain around this, isn't it? You're probably picturing a tiny, miniature courtroom, complete with a little judge in a big wig, peering over spectacles at a particularly recalcitrant slug. While the reality wasn't quite that cartoonish, the underlying seriousness of the process was very real. These weren't mere symbolic gestures born of desperation. They were meticulously documented legal cases, often spanning years, with all the pomp and circumstance a medieval court could muster. Let's think about the mindset here. Remember how we talked about biblical precedents for animal accountability? Well, when it came to insects, the divine hand felt even more apparent. Plagues of locusts are mentioned in Exodus, a clear sign of God's wrath. If these creatures were instruments of divine punishment, then perhaps by engaging them in a human legal framework, you could appeal to a higher power, or at least understand the nature of your collective sin that had brought them upon you. It was a desperate attempt to impose order on chaos, to find a human-scale solution to a problem that felt utterly beyond human control. You couldn't just swat a plague of locusts, could you? Not effectively, anyway. So you tried to serve them papers. The process typically began with the human victims, the farmers, the villagers, the landowners, filing a formal complaint. Imagine the scene. A solemn clerk, scratching on parchment, meticulously documenting the damages inflicted by, say, a colony of particularly voracious caterpillars. The complaint would then be presented to a bishop or a local secular magistrate, who would take it with utmost gravity. You might find yourself thinking, surely, they knew this was a bit much? But for them, it was a perfectly rational, albeit extreme, application of their legal and theological understanding. After all, if God created all creatures, and if all creatures were subject to his law, then perhaps they could be made subject to human law, which was theoretically a reflection of divine law. Once the complaint was acknowledged, the next step was truly astonishing. The insects were formally summoned to appear in court. Yes, you heard correctly. A summons, often read aloud at the affected fields, sometimes even translated into Latin or local dialect, would call upon the accused pests to present themselves. The summons might specify a particular date, time, and location, usually a designated spot in the field or a public square. You can almost hear the crickets chirping in defiance, or perhaps the faint, sarcastic buzzing of a fly as the bailiff reads out the formal decree. Of course, the insects never showed up, and that, surprisingly, was part of the legal strategy. Their non-appearance was taken as a default, an admission of guilt, or at least a sign of their contempt for the court, which only strengthened the human plaintiff's case. It's like trying to serve a subpoena to your garden slugs. You know they won't show, but the act of serving it is the point. Now, here's where it gets even more fascinating and a little bit heartwarming in its sheer absurdity. The insects were often assigned legal representation. That's right, a defense lawyer. Usually a prominent jurist or a local legal scholar would be appointed to argue on behalf of the accused pests. Their job, you might imagine, was not an easy one. What do you say when your clients are literally eating the evidence? These lawyers had to be incredibly creative, often drawing on theological arguments. They might argue that the insects were merely following God's will, fulfilling their natural purpose, or that they too had a right to sustenance. One common defense was that the insects were simply seeking their allotted portion of the earth's bounty, and that perhaps the humans were the ones infringing on their divine rights. Imagine the closing arguments. Your Honor, these caterpillars are not criminals. They are merely hungry citizens of the natural world, operating under divine mandate. It's a job that would make even the most seasoned modern public defender scratch their head. I bet they had the easiest time with billable hours, though. My client was unavailable for consultation, Your Honor. He was busy eating a leaf. The proceedings could be lengthy, involving witness testimonies, from the afflicted farmers, of course, the presentation of evidence, often samples of damaged crops, and even site visits by judges to observe the destruction firsthand. The judge, often a high-ranking ecclesiastical figure like a bishop, would preside over these cases with the utmost solemnity. They weren't just deciding a property dispute. They were mediating between humanity and the natural world, and by extension, between humanity and God. The verdicts, once reached, were as varied as the pests themselves. Sometimes, the court would issue a formal decree of banishment, ordering the insects to leave the area and relocate to a specific, often barren, plot of land designated for them. This decree would be read aloud, sometimes accompanied by a procession to the designated exile site. You can picture the judge, in full robes, solemnly declaring, "By the power vested in me, I command thee, O weevil, to depart these lands and trouble them no more." And I'm sure the weevils immediately packed their tiny bags. One mainstream historical fact is that such trials against weevils occurred in Bern, Switzerland in 1479, and against flies in Autun, France in 1487, with formal sentences of banishment being issued. But the most extreme, and perhaps the most mind-boggling punishment was excommunication. Yes, religious excommunication, typically reserved for heretics and grave sinners, was sometimes leveled against these insect pests. If the insects refused to comply with the banishment order, which, let's be honest, they always did, they could be declared in contempt of court and subsequently excommunicated. This meant they were cut off from the blessings of the church, denied access to sacred spaces, and essentially damned. The logic was that if these creatures were instruments of God, then perhaps by removing them from God's grace, you could render them powerless. A particularly quirky tidbit is that the famous jurist Bartholomeus Chassanius, who served as a defense lawyer for rats in a trial in Autun, France in 1510, argued that his clients could not appear in court because they feared for their lives due to cats lying in wait, and thus their non-appearance was justified. He also argued that a summons must be delivered personally to each rat, which was, of course, impossible. Historians still debate whether these trials were purely symbolic, a form of communal therapy, or if they were genuinely believed to be effective in a spiritual sense. Some scholars argue that they provided a structured outlet for fear and frustration, allowing communities to feel they were actively addressing a problem, even if the legal solution seemed absurd to us today. Others suggest they reinforced the Church's authority and its perceived power over the natural world, even in its most unruly forms. Regardless of their practical efficacy, they highlight a profound difference in worldview. The medieval mind didn't draw the same sharp lines between human and animal, or between the natural and the supernatural that we do. Everything was interconnected, imbued with meaning, and potentially subject to divine and human law. So, as you drift off to sleep tonight, perhaps you'll find a strange comfort in the thought that medieval humans, faced with overwhelming natural forces, didn't just give up. They didn't have pesticides or advanced agricultural science. But they had their courts, their lawyers, and their faith. And sometimes that was enough to make them feel like they were fighting back one tiny, legally challenged insect at a time. It's a testament to human ingenuity, desperation, and an enduring belief in the power of a good legal argument, even when your client is a caterpillar. You find yourself standing on the cold, packed earth floor of a medieval courtroom, though it might look less like the grand halls of justice you imagine and more like a barn, a local lord's hall, or even a simple church antechamber. The air is thick with the scent of damp stone, old wood, and maybe a hint of straw and unwashed bodies, a subtle aroma that whispers of a time long past. Light, hesitant and weak, filters through narrow, high-set windows, casting long, dancing shadows that make the proceedings feel even more theatrical, more dreamlike. This isn't a quick judgment at the village well. This is a formal legal affair, steeped in tradition and an earnest belief in its own solemnity. As your eyes adjust to the dimness, you begin to discern the figures arrayed around the makeshift court. At the front, often elevated on a simple dais or seated behind a sturdy wooden table, is the judge. This isn't necessarily a robed figure with a powdered wig, but more likely a local seigneur, a bailiff representing a lord, or an ecclesiastical official, perhaps a bishop or a canon if the case involves a more spiritual or widespread pest. Their demeanor is grave, their gaze unwavering, for they are presiding over a matter of profound importance to the community. They embody the law, the local custom, and often the will of God in these proceedings. Their authority is absolute, their judgments final, at least in the first instance. You can almost feel the weight of their decisions hanging in the air, palpable as the dust motes dancing in the faint shafts of light. And then you notice the accused. Perhaps it's a sow, grunting softly, tied to a post or held by a sturdy peasant, her snout occasionally rooting at the floor. Or a goat, bleating nervously, its eyes wide with an uncomprehending fear. Or even a collection of tiny, buzzing insects, their alleged crimes read aloud over a jar or a sample of blighted crops. The sheer absurdity of it all might make you want to chuckle, but the faces around you are grim, earnest, and utterly devoid of humor. For them, this is no joke. This is justice. What truly elevates these spectacles from mere bizarre anecdotes to legitimate legal history is the astonishing degree of procedural fairness, at least by medieval standards, afforded to these non-human defendants. You see, the medieval legal system, for all its quirks, was deeply rooted in the idea of due process, a concept that, surprisingly, extended even to beasts. When an animal was accused of a crime, say, a pig for savaging a child, or a swarm of locusts for destroying crops, it wasn't simply condemned out of hand. Oh no, it was granted its day in court. Imagine the scene. A formal accusation is read aloud, often in Latin or the local vernacular, detailing the beast's alleged transgressions with a seriousness usually reserved for human felonies. The pig, perhaps, is accused of maliciously and with forethought, causing injury or death. You might find yourself stifling a giggle, wondering if the pig had a motive, perhaps a long-standing grudge against the toddler's noisy rattle. But the scribe, hunched over his parchment, writes it all down, meticulously, as if recording the confession of a hardened criminal. And here's where it gets truly fascinating. The animal was almost invariably assigned legal counsel. Yes, you heard that right. A lawyer. A human, articulate, often highly educated lawyer, whose sole job was to defend the accused beast. You can almost picture them, perhaps a young, earnest advocate eager to make a name for himself, or an older, cynical one who'd seen it all. They would stand before the judge, perhaps adjusting their simple tunic, and argue on behalf of a client who could only grunt or bleat. Their arguments, of course, couldn't rely on the animal's testimony, but rather on challenging the human witnesses, questioning the circumstances of the alleged crime, or even arguing for mitigating factors. Perhaps the pig was provoked? Perhaps the child wandered into a dangerous area? The lawyer might even suggest that the animal was merely acting on instinct, or that its owner was truly to blame for negligence. It makes you wonder what kind of billable hours they charged for a client who couldn't even sign a retainer agreement. Objection, Your Honor. My client pleads Oink. The prosecution, too, was a formal affair. The victim, or their family, would present their case, often through a designated representative or a public prosecutor if the crime was deemed against the community. Witnesses, all human, would be called to testify, detailing the events, describing the damage, and recounting the horror of the animal's actions. You might hear a farmer passionately describe how his fields were laid waste by a plague of caterpillars, or a grieving parent recount the tragic encounter with a rogue bull. The court would listen, taking notes, weighing the human testimony against the silent presence of the accused. Serving a summons to an animal, especially a wild one or a swarm of insects, presented its own unique challenges. For domestic animals, a formal summons would be read aloud to the owner, effectively commanding them to bring their animal to court. But for wild animals or pests, the process became wonderfully, hilariously intricate. Imagine a court official, perhaps a bailiff, trudging out to the infested fields, reading a formal legal summons aloud to a colony of rats, or a swarm of locusts, commanding them to appear in court on a specific date and time. By the authority vested in me, I hereby summon you, O ye blight of the fields, to appear before the esteemed court on the 3rd day of the harvest moon, to answer for your heinous crimes against the crops of this parish. You can almost hear the crickets chirping in response, perhaps a tiny, sarcastic cough from a particularly brazen beetle. This quirky, fringe tidbit of medieval legal practice highlights the depth of their commitment to procedural correctness, even when it bordered on the absurd. Once the formal proceedings began, the processes mirrored those of human trials. There would be a formal reading of the charges, the presentation of evidence from human witnesses, as the animals, naturally, exercised their very literal right to remain silent, and even a form of cross-examination of the human witnesses. The defense lawyer, in a surprising display of legal ingenuity, might argue points of law, challenge the jurisdiction of the court, or even present character witnesses for the animal's good behavior prior to the incident. They might even cite biblical passages or local customs that could mitigate the animal's guilt. Historians still debate whether these elaborate procedures were truly about holding animals morally accountable, or if they served as a deeply symbolic way for communities to process trauma, reaffirm social order, and exert control over the unpredictable forces of nature. Was it justice, or merely a very elaborate coping mechanism? This level of detail, this commitment to a formal court process, wasn't just for show. It was deeply ingrained in the medieval legal mindset, which held that all creatures, by virtue of existing within God's creation, were subject to divine and human law. A mainstream historical fact is that these trials were meticulously recorded in official court documents, often in Latin, complete with names of judges, lawyers, witnesses, and the specific charges and verdicts. These aren't just folktales. They are verifiable historical events, preserved in the dusty archives of European towns and monasteries. The sheer volume of these records, particularly for pig trials, underscores their regularity and the serious intent behind them. The court would deliberate, sometimes with the aid of a jury of local peasants or burghers, who would listen to the arguments, weigh the evidence, and ultimately deliver a verdict. The judge would then pronounce sentence, often with a solemnity befitting a capital crime. The medieval mind saw no inherent contradiction in this. An animal that committed a grave act, particularly one that resulted in human death or severe economic loss, was seen as having stepped outside its natural order, perhaps even as an instrument of evil or divine wrath. Therefore, it needed to be purged, punished, and its actions legally acknowledged. So, as you stand there, watching the proceedings unfold, you gain a new appreciation for the medieval concept of justice. It was a world where legal formality extended to the barnyard, where lawyers argued passionately for clients who couldn't utter a word, and where judges pronounced solemn sentences upon creatures who were utterly bewildered by the entire process. It was serious, it was strange, and it was undeniably a day in court. You shuffle your feet quietly, perhaps a little nervously, as you step further into the dimly lit medieval courtroom. The air hangs heavy with the scent of damp earth, unwashed wool, and a faint, peculiar musk that might just be accused pig. You've seen the pig in the dock, its snuffling snorts echoing slightly off the stone walls, but now you're pondering the truly baffling question. How on earth do you gather evidence when your primary suspect is, well, a pig? or a goat, or a plague of locusts. It's not like you can read them their rights, is it? Anything you oink can and will be used against you in a court of law. No, that just doesn't quite roll off the tongue. The first, most obvious challenge you face is the profound, unshakable silence of the accused. Your defendant, whether it's a so accused of infanticide or a beetle for crop destruction, is not going to offer a confession, plead the fifth, or even offer a coherent alibi. They won't be pointing any tiny hooves or antennae at another, more culpable creature. So, the medieval legal system, ever resourceful in its peculiar logic, had to rely almost entirely on human testimony and the kind of circumstantial evidence that would make a modern forensic scientist raise a very skeptical eyebrow. Imagine, if you will, the scene. A stern-faced judge, perhaps a local lord or an ecclesiastical official, sits on a raised dais. Before him, the accused animal, often restrained, perhaps looking utterly bewildered or, in the case of a pig, merely hungry. The prosecution, typically a representative of the community or the aggrieved party, begins to present its case. The star witnesses, other humans. You see villagers, farmers, and even the victims themselves, if they survived, of course, stepping forward, their voices hushed or indignant, to recount the alleged misdeeds. "I saw it with my own eyes, my lord," a farmer might declare, pointing a trembling finger at a particularly stocky sow. "That beast, it did enter my sty and devour my piglets." The court would listen intently, perhaps jotting down notes on parchment. This eyewitness testimony was paramount. In a world without advanced forensic techniques, the word of a human who claimed to have seen the act was often the strongest form of evidence available. Think about it. Without CCTV or DNA analysis, if someone swore they saw a dog bite a child, that was pretty much it. This reliance on direct human observation was a mainstream historical fact in medieval courts, not just for animal trials but for human ones too. It shaped how justice was perceived and delivered, placing immense weight on personal accounts. But what if no one saw the act? Well, then you enter the murky waters of circumstantial evidence. You might hear testimony about the animal's general character. "That goat," someone might grumble, "always had a mean look in its eye, always butting things, always trying to escape its pen." Or, "That sow was known to be a wanderer, always rooting where she shouldn't." Such character assassination, while perhaps frowned upon in modern courts, was perfectly acceptable. It painted a picture of a creature prone to mischief, making the current accusation seem all the more plausible. It was like saying, "Your Honor, my client's cat has a history of knocking over expensive vases, so it's highly probable it was the one who shattered the Ming Dynasty artifact." You can almost hear the judge sighing. "Another one, Mittens?" Physical evidence, though rudimentary, also played a role. If a pig was accused of attacking a child, the child's injuries would be presented. If an ox was accused of goring someone, the gored person would be there, perhaps still bandaged. Property damage, like trampled crops or broken fences, would be described, and sometimes the damaged goods themselves might be brought into the courtroom. A broken fence post perhaps leaning awkwardly against the wall, serving as a silent, splintered witness. Imagine the logistics of bringing a field of ruined wheat into the courtroom. You'd need a very large cart, and probably a very patient bailiff. Then there's the question of the animal's presence at the scene. If a dog was found near the body of a victim, or a rat infestation was discovered in a granary, their very presence was considered damning. It was often assumed that if the animal was there, and a crime had occurred, the animal was inherently involved. There wasn't much room for wrong place, wrong time, arguments for our four-legged friends. You could hardly argue, "My client, the rat, was merely passing through the granary on its way to a very important cheese convention." The judge would just blink slowly. But here's where things get truly fascinating, and perhaps a little unsettling. What about the animal's lack of response? There's a quirky, fringe tidbit that sometimes the animal's behavior during the trial was interpreted as a form of evidence. If a pig remained stubbornly silent and unrepentant, it might be seen as a sign of its hardened, evil nature. If it squealed or struggled, it might be interpreted as guilt or defiance. It was a bizarre form of reverse psychology applied to a creature that likely just wanted to go home and nap. You can almost hear the prosecutor dramatically declaring, "Observe, Your Honor, the defendant's utter lack of remorse, not a single tear shed," as if a pig was going to break down sobbing on the stand. Historians still argue whether these trials were purely symbolic, a way for communities to exercise control and express collective anxieties, or if there was a genuine belief in animal culpability. This debate often circles back to the interpretation of evidence. If the animal couldn't speak, could it truly be judged by human standards? Some scholars suggest that the trials were a form of public theater, a way to reinforce moral order and send a message to the community about proper conduct, even if the culprit couldn't comprehend it. Others believe that the medieval mind, deeply rooted in biblical interpretations and a less rigid distinction between human and animal souls, genuinely believed these creatures could be agents of evil or at least responsible for their destructive actions. The process of gathering evidence also involved the owner of the animal, who was often a key figure in the proceedings. They might be called upon to testify about their animal's habits, their attempts to control it, or even to pay fines on its behalf. In some cases, the owner might even be held partially responsible for the animal's actions, especially if negligence was proven. It was a bit like your parents being called into school because your pet hamster chewed through the principal's prize diploma. Except, with much higher stakes and potentially a lot more public humiliation. For insect trials, the evidence was often the sheer scale of the devastation. A field ravaged by caterpillars, a vineyard destroyed by beetles. The damage itself was the primary proof of the insect's crime. The court would hear testimonies from farmers, perhaps even a priest who had witnessed the blight. Then, the legal proceedings would often involve elaborate rituals of excommunication or banishment, essentially telling the insects, "You are hereby ordered to leave this parish, and if you don't, well, we'll try to pray you away even harder." It sounds ridiculous to our modern ears, but in a world where God's will was seen in every natural event, these were serious attempts to exert control over forces they otherwise couldn't comprehend. Ultimately, the interpretation of this animal evidence rested squarely on human shoulders. The judges, often men of the cloth or learned legal scholars, would weigh the human testimonies, the circumstantial clues, and the perceived character of the beast. They applied human legal principles, concepts of trespass, assault, and damage, to creatures that operated on instinct. It was a one-sided conversation, a monologue of accusations directed at a speechless, often bewildered, defendant. And yet, for centuries, this was how justice was sought in the hidden world of medieval animal trials, a testament to a mindset so profoundly different from our own, where even the lowest beast could be dragged into court and made to answer for its deeds. You've sat through the solemn proceedings, you've witnessed the earnest presentation of evidence, and you've even seen a bewildered pig trot into the courtroom, presumably wondering if it left the oven on. Now, the moment of truth arrives, and the air thickens with anticipation, a heavy silence descending upon the medieval courtroom. The judge, often a local lord or a learned cleric, clears their throat, and you lean forward, your brow furrowed with a mix of curiosity and a touch of disbelief. What, you wonder, could possibly be the verdict for an animal? And what, for goodness sake, would the punishment entail? The range of verdicts was, perhaps surprisingly, quite varied. It wasn't always a foregone conclusion that the accused beast would be found guilty. Sometimes a lack of sufficient evidence, or perhaps a particularly persuasive advocate for the animal, could lead to an acquittal. But for the most part, especially in cases involving direct harm to humans, the scales of justice often tipped against the furry or scaly defendant. When guilt was established, the consequences could be grim, reflecting the deeply held belief that these creatures, though lacking human reason, were still accountable for their actions under God's law. Let's start with the lighter end of the spectrum, if such a thing can even be applied to a medieval animal trial. Occasionally, the punishment might involve a fine. Now, you're probably picturing a pig fumbling for a coin purse, or a goat trying to remember its PIN number for the local medieval ATM. Of course, that's not quite how it worked. Since animals couldn't exactly pay up, the fine would fall upon their owner. This wasn't just about property damage. It was often a penalty levied against the human who was deemed responsible for failing to control their beast. Imagine, if you will, being told your prize-winning sow just cost you a significant portion of your annual income because she decided to redecorate the neighbor's garden with her snout. Certainly put a new spin on pet insurance, didn't it? These fines could be substantial, reflecting the severity of the animal's transgression and serving as a deterrent to other animal owners. For those more ethereal, often unseen, culprits, the insect pests we touched upon earlier, the verdicts and punishments took on a decidedly spiritual dimension. You recall those cases against locusts or caterpillars, don't you? When found guilty of devastating crops, these swarms could face excommunication. Yes, you heard that right. The Church, with all its solemn authority, would issue a formal decree, banishing the insects from the land and forbidding them from consuming the blessed produce. It's certainly a unique approach to pest control, far less messy than a can of bug spray, but perhaps also a tad less effective. Some scholars still debate whether these excommunications were genuinely believed to drive the pests away, or if they were more a ritualistic act designed to reassure a terrified populace that something was being done, even if that something involved telling a beetle it was no longer welcome at Sunday Mass. You can almost hear the tiny, unrepentant buzz. But then, we arrive at the truly chilling aspect of these trials: the ultimate punishment. For animals found guilty of serious crimes, especially those involving human death or severe injury, the verdict was often public execution. And these weren't quiet, discreet affairs. Oh no, these were spectacles designed to serve as a stark warning, much like human executions of the time. The most frequent recipient of this grim justice was, unsurprisingly, the pig. Given their close proximity to human settlements, their often roaming nature, and their sheer physical power, pigs were frequently involved in accidents, some of which proved fatal to children or infirm adults. You stand in the bustling market square, the air thick with the smell of damp earth and unwashed bodies. A hush falls over the crowd as the condemned arrives. It's a pig, perhaps a large sow, led by a rope, sometimes even dressed in human clothes as a grotesque parody of a criminal. This wasn't just some random pig. This was a pig found guilty by a court of law. The methods of execution mirrored those used for humans: hanging, burning at the stake, or even burial alive. Hanging was particularly common for pigs, often carried out on a scaffold, just as it would be for a human felon. Imagine the scene: a gallows erected in the town square, and a pig, not a person, being led up the steps. It's a truly surreal image, isn't it? One mainstream historical fact that underscores the seriousness of these proceedings is the sheer number of documented pig executions. Throughout medieval and early modern Europe, hundreds of cases are recorded, with the pig being by far the most commonly executed animal. For instance, in France alone, there are records of numerous pigs being tried and executed for infanticide, some even having their snouts mutilated beforehand, a form of public shaming mirroring human punishments for certain crimes. These weren't isolated incidents. They were a recurring feature of the legal landscape for centuries. The spectacle of a public animal execution was designed to be deeply symbolic. By treating the animal as a moral agent, capable of committing a crime and deserving of punishment, medieval society reinforced its understanding of justice and order. It was a way of reestablishing balance after a transgression, even if the transgressor was a four-legged creature. The execution served as a powerful visual lesson, not just about the dangers of uncontrolled animals, but about the very nature of divine and human law. It was a way of saying, even nature itself must conform to our rules. Sometimes the methods were even more unusual. A particularly quirky or fringe tidbit from the archives describes an instance where a rooster was put on trial in Basel, Switzerland, in 1474. This crime? Laying an egg. Yes, an egg. Medieval beliefs sometimes associated such an anomaly with witchcraft or demonic influence, believing these eggs could hatch into a basilisk, a mythical serpent with deadly powers. The poor rooster was found guilty of unnatural crime and publicly burned at the stake, egg and all. You can just picture the bewildered look on the rooster's face, probably thinking, I just laid an egg. What's the big cluckin' deal? It truly highlights the fascinating, and at times terrifying, blend of legal process and superstitious belief that characterized these trials. The public nature of these punishments was key. They were not just about retribution. They were about deterrence and social cohesion. By executing the animal, the community collectively purged the perceived evil or disorder it represented. It was a ritualistic act that reaffirmed human dominance over the natural world and the inviolability of human life. The condemned animal was often paraded through the streets before its execution, drawing crowds, much like human criminals. The local executioner would carry out the sentence with the same solemnity and grim professionalism as they would for a human. It was all part of the theater of medieval justice, a macabre performance designed to reinforce societal norms and the authority of the law. And so, as the final blow falls, or the rope tightens, you witness the grim conclusion of a medieval animal trial. The crowd disperses, perhaps with a sense of order restored, perhaps with a shiver down their spine. You, however, are left to ponder the sheer weight of these proceedings, the earnestness with which these communities applied their laws to creatures that could not comprehend them. It's a stark reminder of a world where the lines between human and animal, law and nature, were drawn in profoundly different ways than they are today. A world where justice for the accused beasts was a very real, and often very final, affair. You've sat through the trials, heard the somber verdicts, and perhaps even imagined the collective sigh of a medieval village as a condemned pig was led to its fate. It's easy to feel a chill wind blow through these forgotten courtrooms, a sense of grim, unyielding justice where a beast's life hung by the thinnest thread of human judgment. But wait, before you drift off entirely convinced that every medieval animal trial ended with a one-way trip to the gallows or the chopping block, lean in a little closer. Because even in this peculiar legal landscape, there were whispers of something else, the rare, almost miraculous glimmer of mercy. Imagine the scene. The same hushed courtroom, the same stern-faced judge, the same rustle of heavy robes, and perhaps the faint, earthy scent of straw clinging to the air. The accused, a sturdy sow, let's say, stands or perhaps snuffles contentedly in the dock, seemingly oblivious to the gravity of the accusations. Witnesses have testified, evidence, such as it was, has been presented, and the verdict, you assume, is a foregone conclusion. But then something shifts. A lawyer, perhaps a particularly earnest one, rises not to simply defend the animal's character, good luck with that, but to appeal to a higher principle or perhaps a very earthly practicality. These instances of reprieve, of unexpected acquittals, were rarer than a unicorn sighting at a jousting match, but they did happen. They weren't about the animal suddenly developing the power of speech to declare its innocence, of course. No, these were moments where human intervention, legal technicalities, or even the sheer economic value of the accused beast swayed the scales of justice. You see, while the medieval mind often equated animal wrongdoing with human sin, it also possessed a pragmatic streak, especially when a valuable resource was on the line. Consider a case, perhaps, where an ox, essential for plowing the communal fields, was accused of goring a villager. The initial judgment might be swift and harsh, but then a collective plea emerges. The villagers, facing starvation without their trusty beast of burden, might petition the lord or the ecclesiastical court. They might argue that the ox, though powerful, was provoked, startled by a sudden noise, or that the victim had trespassed into its enclosure. This isn't just a plea for an animal's life. It's a plea for the community's survival. And sometimes, just sometimes, these pleas resonated. It's like when you're arguing with your smart home device, and it finally understands your request, but with far higher stakes and a lot more grunting involved. One of the fascinating aspects of these occasional acquittals lies in the subtle ways medieval legal minds grappled with the concept of mens rea, or the guilty mind. While animals were largely seen as incapable of malice aforethought in the human sense, their actions were still judged. However, when an appeal was made, lawyers might argue that the animal acted out of instinct, fear, or even simple clumsiness, rather than deliberate malice. This was a subtle but significant legal nuance, often borrowed from the evolving human legal codes of the time. Historians still argue whether these acquittals were genuine acts of mercy, reflecting a nascent understanding of animal sentience, or merely pragmatic decisions based on economic necessity or social pressure? Was it compassion, or simply cost-benefit analysis? The truth, as often happens in history, is likely a murky blend of both. Sometimes the reprieve came not from an acquittal, but from a commuting of the sentence. Instead of execution, an animal might be exiled, banished from the village boundaries, or sentenced to a life of hard labor under strict supervision. Imagine the scene. A pig, having survived its trial, being led out of town with a tiny, symbolic banishment scroll tied to its tail, perhaps looking utterly bewildered. Well, that was a close shave. You can almost hear it think, now, where's the nearest mud puddle in exile? It's a quirky tidbit of history that shows the medieval mind's capacity for both severity and, occasionally, creative problem-solving. These were not always acts of pure benevolence, but often practical solutions to thorny legal and social dilemmas. There are documented cases, for instance, of accused animals being pardoned due to the intervention of powerful patrons, or because the court found a procedural error. Imagine a scene where the animal's defense attorney, yes, they had them, usually appointed by the court, often a young, ambitious legal mind eager to make a name for himself, even if his client was covered in mud, successfully argues that the initial indictment was flawed, or that a witness's testimony was contradictory. You can almost hear the judge sighing, running a hand over his tired face, thinking, another Monday, another technicality saving a swine. Can't a man get a straightforward goring case anymore? This mainstream historical fact, the increasing professionalization of the legal system in the later Middle Ages, meant that even these bizarre trials became subject to more rigorous, if still peculiar, legal scrutiny. Lawyers were getting good at finding loopholes, and sometimes those loopholes were big enough for a whole ox to walk through. The sheer value of an animal could also serve as a powerful argument for clemency. A prize breeding sow, a strong draft horse, or a flock of sheep essential for wool and meat, these were not disposable commodities. Losing such an animal to execution could devastate a family or even an entire hamlet. The court, weighing the crime against the economic hardship it would inflict, might opt for a less drastic punishment. Perhaps the owner would be fined heavily or forced to pay restitution to the victim's family, thus allowing the animal to live and continue its productive life. It was a pragmatic form of mercy, where the animal's life was spared not out of sentimentality, but out of necessity. Occasionally, the concept of provocation played a role. If a dog, accused of biting, could be argued to have been provoked by a stone-throwing child or a threatening stranger, its sentence might be mitigated. While the animal itself couldn't articulate its defense, its human advocate could paint a picture of an animal reacting naturally to a perceived threat. These were complex arguments, requiring a subtle understanding of animal behavior, by medieval standards at least, and a persuasive legal tongue. It was a bit like trying to explain to your cat why it shouldn't knock things off the shelf, but then realizing it's just being a cat, and perhaps the shelf was too crowded anyway. So, as you picture these courtrooms, remember that not every story ended in tragedy. In the flickering candlelight, amidst the stern faces and hushed whispers, there were moments when the scales of justice, surprisingly, tilted towards compassion, or at least, towards practical leniency. These were the unexpected acquittals, the rare reprieves that remind us that even in the most peculiar corners of legal history, a glimmer of mercy could, and sometimes did, shine through. You settle deeper into your softest blanket, perhaps with a mug of something warm steaming gently beside you, and you might be thinking, okay, but why? Why on earth did people in the Middle Ages put animals on trial? It's a question that whispers through the centuries, a curious echo from a world that seems so utterly alien to our own. To truly understand, you need to gently step into the medieval mind, a place where the sacred and the mundane were inextricably woven together, where God's presence was felt in every rustle of leaves and every creak of the floorboards. The bedrock of this peculiar legal system wasn't some whimsical notion, but rather a deeply ingrained theological conviction. Imagine, if you will, a world where the Bible wasn't just a book, but the literal, living blueprint for existence, a divine instruction manual for all of creation. And in that manual, nestled amidst commandments for humanity, were some rather intriguing directives concerning animals. Let's start at the very beginning with Genesis. You know the story. God creates man and woman in his own image, and then he grants them dominion over the fish of the sea, the birds of the air, and every living thing that moves on the earth. Now you might hear dominion and immediately think absolute power. But in the medieval mind, it came with a colossal caveat: responsibility. This wasn't a license to do whatever you pleased. It was a sacred trust. Humanity was God's steward, tasked with overseeing his creation, and that meant ensuring everything operated within his divine order. If a part of that order, say, a rogue pig, went violently astray, it wasn't just a practical problem. It was a theological one, a disruption that needed correction. But the biblical precedent gets even more direct and, frankly, a little startling. Turn your mind to the book of Exodus, specifically chapter 21, verse 28. This is a mainstream historical fact that underpins centuries of animal law. If an ox gores a man or a woman to death, the ox shall be stoned, and its flesh shall not be eaten. But the owner of the ox shall be clear. You heard that right. Not just a suggestion, but a direct command from God, delivered right alongside the Ten Commandments. This wasn't some obscure footnote. It was clear as day. If an animal, particularly one that was part of the community's livelihood, caused a human death, it had to be put to death. The animal, even without human understanding or intent, was seen as having caused a transgression against God's law and the community's well-being. It's like if your Roomba accidentally ran over your pet hamster, you might be sad, but you wouldn't consider the Roomba morally culpable. The medieval mind, however, would be lining up tiny stones for that Roomba. This brings us to the thorny question of original sin and the nature of animals. Medieval theologians, deeply influenced by thinkers like St. Augustine and later Thomas Aquinas, grappled with the idea of animal consciousness and morality. They generally concluded that animals lacked the rational soul and free will that humans possessed. So how could an animal sin? This is where the nuances get delightfully intricate. Historians still debate whether medieval theologians truly believed animals possessed a soul in the same way humans did, or if their trials were more about a symbolic cleansing of communal sin. The prevailing view wasn't that the pig chose to be malicious in the human sense, but that its actions, when harmful or deadly, were a manifestation of the fallen world, a disruption of the divine order that needed to be purged. The animal, in a way, became a vessel for a violation, and the trial was a way of ritually cleansing that violation from the community and the land. Think of it this way: the animal wasn't necessarily being punished for its intent, but for the consequence of its actions, which had broken God's law. It was less about the animal's personal guilt and more about the community's need to restore cosmic balance. A pig that killed a child wasn't just a tragedy. It was a stain, a disruption that could invite God's wrath upon the entire village. Executing the animal was a form of purification, a public declaration that the community upheld divine justice. It's a bit like when you accidentally spill your entire breakfast smoothie on the pristine white carpet. You don't blame the smoothie for intending to make a mess, but you absolutely have to clean it up, right? For medieval folks, the cleaning up involved a formal trial and sometimes a very public execution. And then we descend into the truly fascinating, the wonderfully quirky fringe tidbit of medieval animal law, the excommunication of pests. Yes, you heard that correctly. Imagine a solemn court not prosecuting a pig, but a swarm of locusts or a colony of rats, or even caterpillars. These weren't just nuisances. They were perceived as scourges sent by God, or perhaps even by demonic forces, to punish the community. The solution: call in the church. Bishops would issue formal summonses to these creatures, ordering them to appear in court. When, predictably, the insects failed to show up, because, they were busy being insects, they would be condemned in absentia. The ultimate punishment? Excommunication. The church would formally banish them from the community, from the land, and from God's grace. It was a spiritual weapon wielded against the natural world, a desperate attempt to assert divine order over chaos. You can almost picture the tiny, bewildered lawyer appointed to defend the caterpillars, scratching his head and wondering how exactly he was supposed to serve a subpoena to a swarm. "Your Honor," he might sigh, "my client appears to have absconded." Again, this wasn't just symbolic, it was deeply serious. The belief was that the Church, through its divine authority, could literally command nature. If the pests persisted, it wasn't because the excommunication failed. It was because the community itself must still be harboring some unconfessed sin. It pushed the responsibility back onto the humans, forcing introspection and repentance. It was a theological feedback loop, if you will. So, the theological roots of these trials twine around several key concepts. 1. Biblical literalism * direct commands from the Old Testament were taken as divine law, applicable to all aspects of life, including animal behavior. 2. Divine order and justice * God created an orderly universe. Any significant disruption, especially one involving death or destruction of property, was a breach of that order that demanded restoration through formal justice. 3. Purification of the community * a crime, particularly a violent one, was seen as defiling the community. The trial and punishment of the animal served to ritually cleanse the land and its people, ensuring they remained in good standing with God. 4. Consequences not intent * while animals weren't believed to possess human reason or free will, their actions had tangible, often devastating, consequences that needed to be addressed within the divine legal framework. It was the act that mattered, and the need to restore balance. 5. The Church's authority over nature * especially in cases of pest trials. The Church believed it held spiritual dominion, capable of influencing the natural world through prayer, curses, and excommunication. You can almost feel the weight of this worldview, the pervasive sense that everything was interconnected, that a rampaging pig wasn't just a farm animal gone wild, but a ripple in the fabric of God's design. It's a profound contrast to our modern understanding, where we might attribute such an incident to instinct, lack of training, or perhaps just a particularly bad day for the pig. Back then, it was a matter for God, for the courts, and for the collective soul of the community. It's a strange thought, isn't it? That a grunt from a pig might have been interpreted as a plea, or perhaps a defiant refusal to acknowledge the court's authority. "No contest, Your Honor," the pig might have grunted before being led away. This deep theological underpinning gave the animal trials their solemnity, their meticulous legal procedures, and their often brutal outcomes. It wasn't a joke to them, not really. It was a serious, spiritual undertaking, designed to uphold God's law in a world where His presence was felt in every shadow and every sunbeam. You've journeyed through the bizarre legal landscape of medieval animal trials, peering into the solemn faces of judges and the bewildered eyes of accused livestock. But as the flickering torchlight casts long shadows across the courtroom, you begin to wonder, what was the point of all this? Were these merely eccentric curiosities, or did they serve a deeper, more profound purpose in the tapestry of medieval life? As you settle deeper into your imaginary velvet armchair, perhaps with a soft blanket pulled up to your chin, you'll discover that these beastly tribunals weren't just oddities. They were vital threads woven into the very fabric of medieval society, reflecting and shaping communities, property rights, and the delicate balance of social order. Imagine, if you will, the bustling, often chaotic world of a medieval village. Life was precarious, dependent on the land, on livestock, and on the strict adherence to a divinely ordained order. When a pig devoured a child, or a swarm of locusts decimated crops, it wasn't just an unfortunate accident. It was a profound disruption. It challenged the very notion of order, of God's benevolent gaze, and of humanity's dominion over the natural world. These trials, therefore, were a way to reassert control, to impose human law onto the unruly corners of existence, even if those corners had hooves or chitinous shells. They were a performative act, a public declaration that someone was accountable, and that justice, in its medieval form, would be served. Consider the intricate web of property rights that defined much of medieval life. Land, livestock, and produce were the bedrock of wealth and survival. When an animal committed a crime, especially one involving harm to a person or destruction of property, it wasn't just a matter of punishment. It was a question of liability. If your neighbor's bull gored your prize cow, or if his pig rooted up your carefully tended vegetable patch, Who was responsible? The owner? The animal itself? These trials provided a formal mechanism to address such grievances, often leading to the confiscation or execution of the animal, which, for all intents and purposes, was a significant loss of property for its owner. It was a stark reminder that animal ownership came with responsibilities, and that negligence or even just bad luck could result in a tangible economic penalty. Think of it as the ultimate, rather extreme medieval insurance claim, where the policy payout was often the public execution of your asset. The very act of prosecuting an animal reinforced the legal system's authority. It wasn't just about human-on-human crime. It was about the law's reach extending into every corner of existence, demonstrating its omnipotence. The solemnity of the court, the presence of judges, lawyers, and even the occasional witness, often human, testifying to the animal's misdeeds, obviously, since the animal couldn't exactly take the stand and plead its case, lent immense gravitas to these proceedings. It solidified the power structure, reminding everyone, from the humblest peasant to the highest lord, that the law was watching, and its judgments were absolute. This was particularly crucial in an era where central authority could be tenuous, and local lords or courts needed to project an image of unwavering control. Furthermore, these trials served as a powerful deterrent, not necessarily to the animals themselves. You'd be hard-pressed to find a pig who, after witnessing a fellow swine's public hanging, decided to turn over a new, less murderous leaf, but to their human owners. If your animal was a known menace, you might face social ostracism, fines, or the very real risk of losing a valuable asset to the gallows. This implicitly encouraged owners to better manage their livestock, to keep their pigs penned, their dogs leashed, and their oxen from wandering into mischief. It was a subtle yet effective way of regulating animal behavior by regulating human responsibility, ensuring a degree of peace and order within the community. It's like when your pet goldfish looks at you suspiciously as you flush his deceased predecessor down the toilet. You know he doesn't understand, but you still feel a slight pang of guilt, right? Multiply that by 1,000 and add public shame. The public spectacle of these trials and executions also played a vital role in maintaining social order. Medieval justice was often a highly visible affair, designed to instruct, to warn, and to unify the community against perceived threats. The sight of a pig, dressed in human clothes, being led to the gallows, or a swarm of caterpillars being solemnly excommunicated by a bishop, was undoubtedly bizarre, but it was also a communal event. It brought people together, affirmed shared values, and reinforced the moral boundaries of society. It was a dramatic ritual that purged the community of a perceived evil, whether that evil was a human murderer or a particularly destructive rodent. This mainstream historical fact, the importance of public spectacle in medieval justice, underlines why these animal trials, however strange to our modern eyes, fit perfectly within the established norms of the time. Moreover, these trials offered a legitimate alternative to vigilantism. When a community was terrorized by a rogue animal, a wolf preying on sheep, or a bull with a nasty temper, the natural inclination might have been to simply hunt it down and kill it. But by channeling these incidents through the formal legal system, the authorities maintained control, prevented chaotic mob rule, and ensured that due process, however peculiar, was followed. It was a way to manage communal outrage and fear within a structured framework, thus preventing further disorder. Imagine the medieval equivalent of an angry mob with pitchforks and torches, but instead of storming a castle, they're demanding a formal indictment for a particularly troublesome badger. It's almost quaint, isn't it? The theological roots of these trials also deeply intertwined with their societal impact. The belief that animals, particularly those that caused harm, were acting as instruments of the devil, or were themselves possessed, was not uncommon. Prosecuting them was therefore seen as a spiritual act, a way to cleanse the community of demonic influence, or to appease an angry god. When insects were excommunicated, it wasn't just a legal decree. It was a spiritual anathema, a powerful demonstration of the Church's perceived power over the natural world and its ability to intervene on behalf of the faithful. This quirky or fringe tidbit, the idea that animals could be possessed or act as agents of evil, adds another layer of complexity to why these trials were taken so seriously. It wasn't just about the damage. It was about the perceived spiritual corruption. Historians still debate whether these trials were purely symbolic, a theatrical performance designed to reinforce human dominance and legal authority, or if they genuinely reflected a widespread belief in animal culpability. Some scholars argue that while the legal process was formal, the underlying intent was less about punishing the animal and more about punishing the owner or providing a ritualistic outlet for communal anxiety. Others contend that medieval people genuinely believed animals possessed a form of legal agency, however rudimentary, and were therefore capable of committing crimes. Regardless of the precise interpretation, what is clear is that these trials were deeply embedded in the medieval worldview, reflecting anxieties about control, order, and the unpredictable nature of both the human and animal worlds. In essence, these beastly trials were a mirror reflecting the medieval mind, a mind steeped in religious belief, obsessed with order, and deeply interconnected with the natural world. Even if that connection sometimes manifested in the courtroom, they allowed communities to grapple with the inexplicable, to assign blame, to reassert authority, and to maintain a semblance of control in a world that often felt chaotic and unpredictable. They solidified property rights by imposing consequences on animal owners, reinforced social order by demonstrating the law's reach and deterring unruly behavior, both human and animal, and provided a ritualistic outlet for collective anxieties. So, as you drift off, perhaps you'll envision a medieval village, not just with its knights and castles, but with its surprisingly busy animal court, a place where justice, in its most peculiar form, was always on the docket. As the centuries trudge onward, like a particularly sluggish snail making its way across a damp cobblestone, you find the grand, if slightly bizarre, spectacle of medieval animal trials beginning to wane. It's not a sudden, dramatic courtroom finale, mind you. No, there's no gavel dropped definitively declaring, "No more pigs in the dock." Instead, it's a slow, almost imperceptible fade, like an old photograph left in the sun, its vibrant colors gently bleaching away. You start to notice fewer of these peculiar cases popping up in the dusty legal tomes, fewer solemn processions escorting a bewildered goat to its fate. The air in the legal chambers, once thick with the scent of parchment and porcine indignation, slowly begins to clear. This decline isn't a random act of judicial mercy. It's deeply interwoven with a profound shift in human thought, a tectonic plate movement beneath the very foundations of European society. You see, the medieval world, with its deep theological roots and its understanding of a divinely ordered universe where all creatures, great and small, held a place within a moral framework, slowly gives way to something new. The sun, quite literally, begins to rise on the age of reason. Imagine yourself standing on the cusp of the 17th century, feeling the intellectual winds begin to shift. Gone are the days when every unexplained blight or sudden death could be attributed solely to demonic influence or the moral failings of a community. Now, you're encouraged to look for empirical evidence, to apply logic, to question the unquestionable. This burgeoning spirit of inquiry, which will eventually blossom into the Enlightenment, starts to chip away at the very premise of animal culpability. One of the key intellectual currents that washes over Europe is the reevaluation of what constitutes a person in the eyes of the law, and more importantly, what constitutes a mind. You see, for an entity to be guilty of a crime, especially one requiring intent, it needs mens rea, or a guilty mind. And as philosophers and legal scholars begin to grapple with this concept, the idea of a pig harboring malicious intent, or a rat conspiring to destroy crops, starts to feel, well, a little less plausible. It's like trying to explain quantum physics to your dog. You know they're listening, but the deeper concepts just aren't clicking. Think about the influential figure of René Descartes, for instance. He, among others, championed the idea that animals were essentially complex biological machines, automatons without souls, consciousness, or the capacity for reason or moral choice. If an animal is just a sophisticated clockwork mechanism, then how can it be held morally accountable for its actions? You wouldn't put a broken clock on trial for failing to tell time, would you? Though, admittedly, a particularly frustrating alarm clock might tempt you to throw it out a window, which is arguably a form of informal justice. This philosophical stance, while controversial even then and certainly now, gained significant traction and provided a powerful intellectual cudgel against the notion of animal trials. The legal system itself also began to evolve, becoming more standardized, more centralized, and increasingly focused on human-centric principles. The messy, localized, and often religiously inflected justice of the medieval period slowly gave way to more codified laws and professionalized courts. As the concept of property rights became more defined and enshrined, animals increasingly fell into the category of chattel possessions, not moral agents. If your neighbor's cow trampled your prize-winning petunias, the legal recourse shifted from prosecuting the cow for vandalism to suing your neighbor for damages. It was a subtle yet profound reframing. The cow was no longer the perpetrator. It was merely the instrument of damage, much like a faulty tool. You also witness a gradual secularization of the law. While religious influence never entirely vanished, the direct invocation of biblical precedent for animal trials, once a cornerstone, began to diminish. The Church's role in secular legal matters, while still significant, started to recede from its medieval omnipresence. This meant that the theological justifications for prosecuting animals, often rooted in interpretations of Old Testament laws or the idea of animals as agents of divine punishment, lost some of their persuasive power in a world increasingly looking for rational, rather than purely spiritual explanations for earthly events. It's a bit like when your favorite band goes from playing in church basements to massive stadiums. The vibe just changes. The very nature of evidence and proof also undergoes a transformation. As the scientific method begins to take root, there's a growing demand for empirical, verifiable facts. How do you prove a pig had malice aforethought? How do you cross-examine a rat? The practical absurdities of these trials, once accepted within a different worldview, became increasingly glaring under the harsh light of emerging rationalism. The legal community, striving for greater legitimacy and efficiency, found these cases increasingly difficult to reconcile with their evolving standards of justice. Historians still debate whether the decline was primarily driven by intellectual shifts among the elite, philosophers and jurists, or if it was a more organic, grassroots change in public perception. Perhaps ordinary people, too, began to find the spectacle less compelling, more ridiculous, as their world became less mysterious and more understandable through emerging scientific lenses. It's plausible that both forces worked in tandem, creating a gradual, almost imperceptible drift away from these peculiar legal proceedings. By the 18th century, animal trials were largely considered an anachronism, a curious relic of a bygone era. They didn't vanish overnight, of course. Some isolated, truly stubborn pockets of tradition might have seen a rogue animal trial pop up here and there, almost like a strange echo from the past. For instance, one of the very last documented cases in Europe involved a rooster in Switzerland in 1701, accused of laying an egg, which was seen as an unnatural, diabolical act, believe it or not. The poor fowl was sentenced to be burned at the stake. It's a bizarre footnote, a quirky tidbit that highlights just how long some of these ideas lingered, like that one ancient relative who still thinks dial-up is the peak of internet technology. But these were exceptions, not the rule. The general trend was unequivocally towards cessation. You can almost feel the collective sigh of relief from the animal kingdom. No more surprise summonses, no more need for a good lawyer who specialized in squeals and barks. The courts were finally, and perhaps mercifully, becoming exclusively human affairs. The legal landscape was being reshaped, not by divine decree or ancient superstition, but by human reason, observation, and a burgeoning desire for a more logical, consistent system of justice. The animals, whether they knew it or not, were finally off the hook. As you drift deeper into the peculiar annals of medieval justice, you begin to stumble upon tales that are not just strange, but utterly legendary in their bizarreness. These aren't just general accounts of animals on trial. These are the specific, headline-grabbing sagas, the ones that medieval villagers gossiped about over their meager stews, and that still make historians today raise an eyebrow, perhaps muttering, "Well, that happened." You're about to meet some of the most infamous beasts to ever darken a courtroom door, their stories echoing through the centuries like a particularly persistent echo in an empty castle hall. Imagine, if you will, the year 1457, in the small French town of Savigny-sur-Orge. The air is thick with tension, not just the usual medieval smells of wood smoke and, well, other things. A crime of unspeakable horror has occurred. An infant has been brutally attacked and killed. And the prime suspect? A pig. Not just any pig, mind you, but a sow, accused of savagely mutilating and killing the child. You find yourself standing, metaphorically speaking, in the crowded courtroom, the murmuring of the villagers a low hum. This isn't a quick, back-alley summary judgment. Oh no, this is the full Monty of medieval jurisprudence. The pig, you learn, is not merely dragged in. She is formally arrested, held in a prison cell, and, quite incredibly, given a legal defense. A lawyer, a real, human, presumably well-paid lawyer, stands before the court, eloquently arguing for the sow's innocence. He points out mitigating factors, perhaps the pig's general good character, pre-infant incident, of course, or the lack of proper supervision of the child. You can almost see him wiping his brow, thinking, this is going to look great on my resume. The court, presided over by a solemn judge, listens intently. This wasn't some backwater kangaroo court. This was a legitimate legal process, reflecting the deeply held belief that animals possessed a form of legal culpability. Indeed, public executions, like the one this pig faced, were a mainstream historical fact in medieval Europe, designed not just as punishment but as a stark deterrent, a gruesome spectacle for the masses. But alas, the evidence against the Savigny sow is overwhelming. The infant's injuries are too severe, too clearly inflicted by the accused. The verdict comes down guilty. The sentence? Death. And not just any death. The pig is to be dressed in human clothes. Because, we're going for maximum symbolic impact here, and publicly hanged by its hind legs. You can picture the scene. The town square, a makeshift gallows, a crowd gathered, and a poor, bewildered pig, perhaps wondering why it's suddenly wearing a tunic and about to have a very bad day. It's hard not to feel a pang of gentle sarcasm here. Surely, if you're going to execute a pig, at least let it enjoy one last mud bath. The hanging itself is a grim affair, but the sheer effort and formality surrounding it truly underscore the medieval belief in the pig's legal agency. Moving on from the porcine tragedy, you journey eastward to the bustling Swiss city of Basel in the year 1474. Here, the accused is not a pig, but a rooster. Yes, you heard that right, a rooster. And what heinous crime did this feathered fiend commit? It laid an egg. Now, before you scoff, understand that this was no ordinary egg. It was believed that a rooster laying an egg was an act of pure evil, a sign of witchcraft, or, even worse, that the egg would hatch into a cockatrice, a mythical serpentine creature with the head of a rooster, eyes that could kill, and a breath that could poison. The very thought of such a beast emerging from an unholy egg sent shivers down the spines of medieval folk. This quirky, fringe tidbit about the cockatrice myth reveals a deep-seated fear of unnatural occurrences and demonic influence. So, the rooster is apprehended, brought to trial, and charged with the execrable and unnatural crime of laying an egg. You can almost hear the prosecutor, in a solemn voice, present the damning evidence. Exhibit A, Your Honor. A perfectly ovular, somewhat alarming, egg. The rooster, naturally, offers no defense, perhaps clucking indignantly, or just looking confused about why it's suddenly the star of a very serious show. Its lawyer, if it even had one, must have been at a loss. My client merely experienced a slight biological anomaly, Your Honor. Perhaps a case of mistaken identity? He identifies as a hen on Tuesdays. The court, however, takes the matter with utmost gravity. The verdict: guilty of witchcraft and being an agent of the devil. The sentence: burning at the stake. Yes, a rooster, burned at the stake, in the town square. One can only imagine the conversations afterward. Did you see that rooster? What a show-off. Really laid into him, didn't they? The poor bird, along with its infamous egg, is consumed by flames, a stark warning against any other roosters contemplating a gender reveal party gone horribly wrong. As your mental journey continues, you find yourself transported to the fields and vineyards, where the enemies are not individual animals, but an entire, creeping, crawling army. Picture the late 15th century in various parts of France, Switzerland, and Germany, where communities are plagued by infestations of rats, slugs, caterpillars, or, in a particularly well-documented case from 1487, the weevils of St. Julian. These aren't just minor nuisances. These are crop-destroying scourges that threaten entire harvests, leading to famine and despair. So, what do you do when your crops are being devoured by an army of tiny, legally indefensible insects? You take them to court, of course. You witness the village elders, desperate and pious, initiating formal legal proceedings against the pests. Summons are issued, read aloud in the fields where the weevils are supposedly residing, inviting them to appear in court. You hear the town crier, perhaps a little out of breath, shouting into the vineyard, "Hear ye! Hear ye! By order of the court, all weevils are hereby commanded to appear before the honorable judge on the third day of the next full moon." And, just like any good legal drama, the accused insects, being, well, insects, naturally fail to show up. This, however, does not deter the court. Instead, a lawyer is appointed to represent the absent weevils. Yes, an actual human being, perhaps a junior barrister eager for some courtroom experience, stands before the judge, arguing on behalf of the tiny, munching defendants. He might argue that the weevils are merely following their natural instincts, that their actions are an act of God, or that the humans themselves are at fault for cultivating crops in their ancestral habitats. "Your Honor," you might hear him plead, "my clients, though small, have rights. They are merely seeking sustenance, as is their God-given right." Perhaps the plaintiffs could consider a more diverse crop rotation, or a new pest control strategy that doesn't involve a subpoena. The prosecution, meanwhile, argues vehemently for the insect's expulsion or excommunication, citing the damage they inflict. These trials could drag on for weeks, even months, with detailed legal arguments, inspections of the affected fields, and even appeals. Historians still argue whether these insect trials were primarily genuine legal proceedings, with an expectation of compliance, or more of a symbolic ritual for communal catharsis, a way for distressed communities to exert some form of control over uncontrollable natural forces. Regardless, the formality of it all is astonishing. The verdicts varied. Sometimes the insects were excommunicated. Sometimes they were ordered to vacate the premises and move to a designated waste area, a rather optimistic outcome, one might think, for a swarm of weevils. And of course, the insects, being insects, almost never complied, which, you have to admit, makes for a rather poor track record in terms of judicial enforcement. It's like trying to serve a restraining order on a cloud. These are just a few of the more prominent cases that stand out in the bizarre history of animal trials. There were bulls tried for goring, dogs for biting, rats for destroying food supplies, and even a dolphin, in one particularly curious instance, was accused of attacking a fisherman. Each case, however absurd it may seem to our modern sensibilities, was treated with a solemnity that speaks volumes about the medieval worldview. They saw these events not as random acts of nature, but as actions with moral and legal weight, demanding justice, even if that justice was meted out to a bewildered farm animal or a swarm of oblivious insects. It's a testament to a time when the line between human and animal, nature and morality, was far blurrier than we might imagine. You've trudged through the muddy lanes of medieval Europe with us, witnessing the absurd yet utterly serious spectacle of animals in the dock. You've seen pigs marched to the gallows, rats excommunicated, and even insects served with legal summons. It's been quite the journey, hasn't it? A peculiar, fascinating glimpse into a worldview so different from our own, where a beast could stand accused, defended, and condemned. But as you settle deeper into your comfiest spot, perhaps with a soft blanket pulled up to your chin, let's consider something crucial. These specific, formal, legal trials of animals? They were, by and large, a uniquely European phenomenon, especially during the medieval period. It's easy to look back and chuckle, to see it as a relic of a less enlightened time, a charmingly bizarre footnote in legal history. But that distinct European flavor, steeped in a particular blend of Roman law, biblical interpretation, and nascent common law, truly sets these animal trials apart. You see, while humans across the globe and throughout history have always had incredibly complex, often fraught relationships with the animal kingdom, the notion of dragging a goat into a formal court, appointing it a lawyer, and then executing it for murder, That's not something you'd typically find in ancient Mesopotamia, or dynastic China, or pre-Columbian Americas. Think about it. You wouldn't find an ancient Egyptian pharaoh ordering a trial for a sacred cat that had scratched a priest, would you? The Egyptians, with their deep reverence for certain animals, might have seen such an act as an omen, or perhaps even a divine message, but not a crime demanding a legal defense. If a crocodile caused harm, it was a force of nature, perhaps one to be appeased or feared, but not one to be served with papers. Their interactions with animals, while profound, were rooted in a different cosmology, often involving animal deities, mummification, and a very practical understanding of the Nile's wild inhabitants. If a hippopotamus trampled a farmer's crops, you didn't sue the hippopotamus. You probably just sighed, rebuilt, and maybe offered a prayer to Sobuk. And what about the Romans, those masters of law and order? While their legal system was incredibly sophisticated and certainly influenced medieval European law, their approach to animal-induced harm was far more pragmatic. If your ox gored a neighbor, Roman law, under the concept of noxal surrender, typically allowed you to either pay for the damages or, interestingly, surrender the offending animal to the injured party. It wasn't about the ox's culpability, but about your responsibility as the owner. It was a property dispute, not a criminal trial for the beast itself. You wouldn't find a Roman judge asking a lawyer to cross-examine a particularly grumpy mule. They were too busy conquering the known world to bother with such trivialities. Bless their efficient hearts. Shift your gaze eastward for a moment, to the vast, intricate tapestries of Asian cultures. In places influenced by Buddhism or Jainism, the very idea of prosecuting an animal seems utterly antithetical. These philosophies, with their emphasis on ahimsa, or nonviolence towards all living beings, and the belief in the transmigration of souls, would have viewed an animal, even one that had caused harm, not as a criminal but as a being on its own karmic journey. To execute an animal would be to accrue negative karma, to interfere with the natural order, or even to harm a potential ancestor. You wouldn't find a Buddhist monk presiding over a court where a monkey was tried for stealing fruit. More likely, they'd offer the monkey some more fruit and contemplate the impermanence of all things. It's a bit like trying to explain the concept of a tax audit to a particularly enlightened panda, completely missing the point of their existence. Even in indigenous cultures across the globe, where the lines between human and animal are often beautifully blurred, where animals are seen as kin, spirits, or teachers, the concept of a formal legal trial for a beast just doesn't fit. You'd find elaborate rituals for hunting, ceremonies to appease animal spirits, stories of transformation and shared wisdom, and a deep respect for the interconnectedness of all life. If an animal caused harm, it might be seen as a lesson, a spiritual imbalance, or simply the harsh reality of nature, but not a breach of a human-centric legal code. There wouldn't be a tribal council debating the guilt of a wolf that preyed on livestock. Instead, there might be a ceremony to understand why the wolf was driven to such an act, or a prayer for balance. So why then did medieval Europe embrace this peculiar legal practice with such fervor? Historians still scratch their heads over whether these trials were truly about justice, or just a very elaborate way for medieval folks to vent their frustrations at a particularly stubborn cow, or perhaps a deeply ingrained belief in the devil's handiwork. It's a rich, scholarly debate, fueled by the sheer volume of these cases documented in dusty old court records. Perhaps it was the unique theological interpretations of the time, where animals, though lacking a rational soul, were still seen as subject to divine law and, by extension, human law, especially when their actions mimicked human transgressions. Or maybe it was simply a logical, if flawed, extension of a legal system that was trying to impose order on a chaotic world, where even the unpredictable actions of nature needed to be accounted for. But here's the deeper insight, the one that transcends geographical boundaries and historical eras. While the form of these animal trials was unique to medieval Europe, the underlying impulses they reveal are profoundly human and remarkably universal. The impulse to understand, to control, and to mete out judgment when faced with the unpredictable power of the animal kingdom. Think about how we, even today, anthropomorphize animals. You talk to your dog, convinced it understands every word. You attribute mischievous intent to a squirrel that raids your bird feeder. We've always projected human qualities, intentions, and even moral frameworks onto animals. The medieval trials were just an extreme, literal manifestation of this universal human tendency. They weren't just seeing a pig that had trampled a child. They were seeing a murderous pig, a pig that had intended harm, a pig that deserved punishment, just like any human malefactor. It's a bit like when your internet goes out and you start yelling at the router as if it personally offended you. The impulse to attribute agency and malice is strong, even if the target is inanimate, or in this case, non-human. These trials also speak to a universal human desire for order and control. In a world where famine, plague, and war were constant companions, where nature was often seen as a capricious, untamed force, the ability to bring even an animal to justice was a powerful assertion of human dominion. It was a way to say, even you, wild beast, are subject to our laws, our God, our will. It was an attempt to impose a human-made structure on the untamed chaos of the natural world. From building fences to domesticating animals, to, yes, putting a mouse on trial, humanity has always striven to manage its environment and its co-inhabitants. Furthermore, these bizarre legal proceedings highlight the enduring human struggle with the concept of responsibility. When something bad happens, especially something caused by a non-human entity, who is to blame? Is it the animal? Is it the owner? Is it God's will? The medieval trials, in their earnest pursuit of animal culpability, were grappling with this fundamental question in a way that feels utterly alien to us now, but reflects a persistent human need for explanation and accountability. We're still debating animal rights, animal welfare, and even animal consciousness today, aren't we? The medieval trials, in their own peculiar way, were just an earlier, more literal chapter in that ongoing conversation. So, as you reflect on this journey beyond the European courts, remember that while the specific legal performance of animal trials was a unique European flourish, the underlying themes are timeless. The human fascination with, fear of, and desire to control animals, our tendency to project our own understanding onto them, and our constant need to define responsibility in a complex world, these are threads that weave through every culture, every era. The medieval animal trial, in all its strange glory, simply offers a particularly vivid and wonderfully peculiar lens through which to examine these enduring human-animal interactions. It reminds us that our relationship with the creatures sharing our planet has always been, and continues to be, wonderfully, maddeningly, and sometimes hilariously complicated. And so, you find yourself at the very end of our strange journey, standing not in a dusty medieval courtroom, but here, in the quiet of your own space, pondering the echoes of those forgotten animal trials. We've seen pigs in the dock, goats accused, and even insects served with legal summons. But what does this peculiar hidden world ultimately tell us about us? About humanity's own evolving sense of justice? As you settle deeper, you begin to see that these trials weren't just a bizarre historical footnote, a medieval blooper reel. They were a deeply serious, albeit profoundly different, expression of how a society grappled with chaos, sought order, and defined responsibility. You're looking into a mirror reflecting not just medieval values, but also the fundamental human need to make sense of the world, to impose structure where there is none, and to assign blame when things go wrong. Think about it. In a world where the lines between the natural and the supernatural were blurred, where divine wrath was a tangible threat, and where a sudden, violent death by an animal could feel like a monstrous, inexplicable act, what else could you do? You couldn't just shrug and say, "Oh, it was just an animal being an animal." That wouldn't do. That wouldn't restore the balance, or appease the heavens, or reassure a terrified populace. So you brought the beast to court. You gave it a lawyer, you heard the evidence, and you passed judgment. It was a ritual, yes, but a ritual with profound meaning for those who lived through it. It was a way of saying, we are in control. Even the wild, unpredictable parts of our world must bend to our laws or face the consequences. It's almost like trying to get your cat to apologize for knocking over your favorite vase. You know they understand, but they just won't. So you impose your own justice. Our modern legal systems, of course, have moved on. You now live in a world where mens rea, the guilty mind, the intent to commit a crime, is fundamental. An animal, by modern definition, cannot form criminal intent. A dog bites. It's instinct, not malice. A pig escapes and damages property. It's a nuisance, not a premeditated crime. Our justice system focuses on rehabilitation, restitution, and understanding the complex psychological factors behind human behavior. We strive for a nuanced understanding of culpability. We don't execute animals for murder. We might, sadly, euthanize them for public safety, or we hold their human owners accountable. The very idea of a pig standing trial, complete with legal representation, feels so utterly alien to you now, doesn't it? Imagine a medieval pig being assigned a court-appointed therapist for its anger issues. The thought alone is enough to make you chuckle. But this shift, this evolution in our sense of justice wasn't sudden. It was a slow, gradual process, intertwined with the broader intellectual currents of the Enlightenment and the Age of Reason. As scientific understanding grew, and the world became less mysterious, more explainable by natural laws, the need to attribute moral agency to animals for their actions began to wane. The medieval worldview, heavily influenced by religious doctrine, saw animals as part of a divinely ordered cosmos, subject to God's laws, and therefore, in a peculiar way, subject to human interpretations of those laws. The Catholic Church, a central pillar of medieval society, played a significant role in shaping legal thought, often incorporating biblical interpretations of human dominion over animals and divine judgment, which provided the bedrock for the idea of animal accountability. It was a powerful theological underpinning that allowed for the idea that even a rampaging bull could be seen as having violated a moral legal code. And yet, historians still debate whether these trials were truly about moral accountability or simply a pragmatic way to deal with property damage and public fear. Was it genuinely believed that the pig knew it was wrong? Or was it a public spectacle to reinforce order and provide a ritualistic outlet for collective trauma? The truth, as often happens, is probably a complex blend of both. For instance, the quirky tidbit of insect scourges being excommunicated by the Church illustrates this blend perfectly. It was a legal act, a spiritual one, and a desperate plea to control the uncontrollable, all rolled into one. It wasn't just about justice for the victim. It was about reestablishing cosmic order. As you reflect on this, you might also consider the concept of personhood. In the medieval context, animals, particularly domesticated ones, seemed to possess a form of legal personhood that allowed them to be held accountable. They were not merely property. They were entities capable of committing crimes. Contrast this with the later philosophical shift, perhaps best exemplified by René Descartes in the 17th century, who famously viewed animals as mere automata, complex machines without consciousness or feeling. This radical shift in thinking, though post-medieval, highlights the vast chasm that opened up between the medieval perception of animal agency and later scientific and philosophical views. It shows how profoundly our understanding of what an animal is has changed, and with it, our understanding of justice. These trials were also a powerful tool for societal control. When a community was terrorized by a rogue animal, putting it on trial, condemning it, and often publicly executing it, served as a potent deterrent and a public affirmation of human dominance over nature. It was a way of saying, we, the people, through our laws, can tame even the wild beast within our midst. It helped solidify property rights and social order by showing that even an animal that damaged property or harmed a person would face the full force of the law. Perhaps in a few centuries, future historians will look back at our obsession with online cancel culture and wonder if we were trying to put public figures on trial like unruly medieval goats. Who knows what future generations will find absurd about our current legal rituals? Ultimately, the hidden world of medieval animal trials is a profound lesson in humility. It reminds you that justice is not a static, universal concept, etched in stone for all eternity. It is a fluid, evolving construct, shaped by the prevailing scientific understanding, religious beliefs, philosophical frameworks, and societal anxieties of any given era. What seems utterly logical and necessary to one generation can appear absurd and barbaric to the next. These trials force you to question your own assumptions about responsibility, about the boundaries of sentience, and about where humanity draws the line between us and them, between the accountable and the merely acted upon. They stand as a vivid testament to humanity's enduring quest for order, for meaning, and for justice, no matter how strangely or wonderfully it manifests itself. They whisper to you about a time when the world was a little more magical, a little more terrifying, and a whole lot less certain about where the human ended and the animal began. And as you drift off, you can almost hear the faint echoes of a medieval courtroom, where a pig stood accused and humanity wrestled with its place in the grand, bewildering tapestry of existence. Now, as the echoes of those medieval courtrooms begin to fade, and the peculiar images of accused animals soften at the edges of your mind, let your thoughts gently untangle from the curious knots of history. You've journeyed far tonight, through a time that feels so distant, so utterly unlike your own, yet in its core human yearnings for order and understanding, so strangely familiar. Allow the strangeness of it all to become a comforting murmur, a quiet hum in the background of your awareness. The solemn judges, the bewildered beasts, the earnest lawyers, they are now simply whispers of the past, dissolving into the stillness around you. There's no need to hold onto the details, no need to untangle every paradox. Just let the feeling of the story, its gentle absurdity and profound humanity, settle within you like a soft blanket. The world you've explored, with its unique sense of justice, has now receded, leaving you here, safe and sound, in the quiet calm of your own space. You are drifting, effortlessly, towards a peaceful sleep. All the trials, all the judgments, all the questions of right and wrong are gently fading, replaced by the soft, rhythmic breath of the night. You are secure. You are at ease.